Hi, I'm Scot Douglas, the staff attorney with Veterans Legal Institute and an Army veteran. And I am the primary staff member responsible for the estate planning clinic. Sheila-Marie Finkelstein, an attorney in private practice who is a state bar certified specialist in estate planning, is also a military spouse. Her husband is a naval veteran. She and I began the clinic in 2017, initially holding the clinics in person in the Veterans Legal Institute offices in Santa Ana. Over the past several years, we have shifted to holding the clinics virtually via Zoom. This shift has resulted in a need for volunteer pro bono attorneys to assist those veterans who are not technically proficient.
I want to take this moment to acknowledge and appreciate all our veterans and your service to this country. If you have served in the armed forces, we thank you.
I do want to let you know that this is general information only that is current in February 2023 and California law applies. This is not legal advice, and we are not establishing an attorney-client relationship. Topics we're going to cover today are about the state planning clinic, the need for pro bono attorney volunteers, application process, assessing capacity, estate planning documents, trust funding, and benefits.
Our first topic is the estate planning clinic. Scott and I formally established the estate planning clinic in 2017. The clinic is typically held on the second Thursday of each month. Originally, the clinic was held in person in our Santa Ana offices. However, due to the COVID pandemic, we've switched and now all of our clinics are held remotely via Zoom. In our clinic, we handle most general estate planning needs and basic probate improper assistance.
The types of matters that we handle in the estate planning clinic are individual estate planning with and without real property, couples initial estate planning with or without real property, individuals or couples updating an estate plan, one that they've done on their own with another attorney or repeat Veterans Legal Institute client, analysis of a prior plan or analysis of a plan for which they may be a beneficiary. We also will help with preparing probate judicial counsel forms for basic simple probate.
Veterans Legal Institute relies extensively on pro bono volunteer attorneys. Without you, we cannot make this as effective as it is. We cannot help as many veterans as we are able to help, especially given the fact that our estate clinic is now held via Zoom. We need attorneys to volunteer to take on cases pro bono for those clients who cannot participate via Zoom or don't have an email address to be able to do the remote signings and notarizations. We also need attorney volunteers to help those clients who have more complex planning needs, such as multiple special needs trusts, blended families, and so on and so forth. We can help them in the estate planning clinic, but we don't have enough resources to help everyone. So we need attorney volunteers to help us so that we can help all the veterans who apply for assistance. We also need attorney volunteers to help with the probate process. In the clinic, we can help prepare the judicial counsel forms so that the clients can represent themselves in pro per. However, there are some clients who need more assistance than we are capable of providing, and that's where you, the attorney volunteer, comes in. And we ask that you take these probate cases either on a pro bono or very low bono basis, in accordance with the statutory fees, of course. We also need attorney volunteers specifically to help us meet the increased demand for estate planning in the Inland Empire. Veterans Legal Institute currently serves most of Southern California, and the Inland Empire needs more representation. So if you are available to help, please sign up today. Next, we're going to talk about the application process. For attorneys interested in volunteering with Veterans Legal Institute, please email info@vetslegal.com to be added to the case list. How our application process works for the estate clinic is that prospective clients will apply at vetslegal.org. Once their application has been received, Scott will conduct an initial phone call to get additional information and explain the engagement agreement and the Zoom process. At this point, if it's determined that the client is unable to participate via Zoom, or if the matter is outside the scope of representation for our clinic, then our case will be referred to the case list for a volunteer attorney such as yourself to accept. For clients who are determined to be applicable for the estate clinic, we will send them an engagement agreement along with their questionnaire, whether that's the individual questionnaire or the married questionnaire. Once we've received the questionnaire back, we will schedule them for a clinic date. After they have met with Scott and myself for their clinic, we will draft their estate plan and send them a summary for their review and approval. Once they have approved the draft summary, we will schedule them for remote online notarization. And once all of the documents have been executed, then an electronic copy as well as a printed portfolio will be sent directly to the client. For our attorneys who are volunteering, we ask that you follow a similar process to make sure that all clients are getting the same level of service. Then the final part in the process is, if applicable, Ahava Law will record the deeds for any deeds necessary to fund into the trust. The next topic that is incredibly important in the estate planning arena is assessing capacity. There's a scale of capacity ranging from the lowest capacity and testamentary capacity up to the capacity to contract. It's very important that your client has the appropriate level of capacity in order to create their estate planning documents. Testamentary capacity is all that is necessary in order to create a will, whereas the capacity to contract is what is necessary in order to create a trust. Under Probate Code Section 810, there is a presumption that every client has the capacity to create their estate plan, even if the client has a mental or physical disorder. So just because your client may be diagnosed with dementia or Alzheimer's or any other form of mental or physical disorder does not mean they lack the capacity to create their estate plan. It's up to you to determine if they have the capacity to make the plan. You can make that determination based on the sliding scales, looking at the specific facts for that specific client. You can reference Probate Code Section 6100.5, which includes the understanding the nature of the Testamentary Act. Does your client understand what it is they are doing when they're creating the will or the trust? 2, the nature and situation of the property. Does your client understand what assets they have and how they are held and whether or not there is a mortgage on the property? And 3, the relations to natural heirs and beneficiaries. Does your client understand their relationship to their natural heirs at law, such as parents, grandparents, siblings, children, and grandchildren, and their beneficiaries that may not be at law, such as a best friend who has been taking care of them for 50 years. If they understand all 3 of these aspects, then it's fair to say that they have the capacity to create their estate plan. If you have concern about their ability to understand what they are doing or the nature and situation of their property or their relationship to their natural heirs and beneficiaries, then it is okay to ask the client to provide a letter from their doctor stating that they do in fact have the capacity to make these sorts of decisions and to keep that in your files. Generally speaking, we don't ask for that because, again, under Probate Code Section 810, there is a presumption of capacity. So as long as you have not received anything from your client indicating a lack of capacity, it's safe to move forward with the estate planning. Next, we're going to talk about the estate planning documents. An estate plan is not a single document. It is a series of documents that cover all aspects of planning for your life, incapacity, and eventual death. As part of the estate clinic, we provide several documents as a package for each of our clients. These packages are tailored to the specific needs of the clients, but all of them include the same key documents. The primary cornerstone of which is usually the revocable living trust. And the revocable trust, as attorneys know, is the contract which governs their assets both during life and at death. And for our clients, we like to say that the trust is the treasure chest that holds all of your assets and protects all of your loved ones. And you are creating the map to that chest that says exactly how it goes, where it goes, when it goes, why it goes. The other document that we include is a certification of trust. This is a short document. The trust can be 50, 100, 200 pages long. The certification of trust is generally about 3 to 5 pages long, and that gives a short summary of the terms of the trust. This is the information that is necessary for banks, financial institutions, mortgage holders, etc., to give them the information they are entitled to with regards to the trust, while protecting the privacy of the trust, because the information contained in the trust is personal, private, and confidential to the client. The other document that we include in our estate plan is a pour-over will. Pour-over will is necessary for 2 reasons. The first being as a catch-all in case there are any assets that were not properly funded into the trust, either because they were acquired thereafter or for whatever reason. It says that anything not in my trust, I put it into my trust now. The other reason that a will is incredibly important is if the client has minor children, because that is where the legal nomination of guardian is for establishing who will take over legal guardianship of the children if, God forbid, the client should pass away before the children attain the age of majority. The other document that we always include for the client and the client's spouse, if there are 2 people in the plan, is the durable power of attorney for finances. The durable power of attorney for finances, we generally use the California statutory form. However, we have it significantly enhanced to cover a lot of the common aspects that need to be covered. The durable power of attorney is what allows the designated person, usually the other spouse as the primary person, and then thereafter the respected and trusted fiduciary, whether that be a family member or friend. And that allows them to make financial decisions on behalf of the client when they are unable to do so for themselves, whether that's paying bills, dealing with the IRS, wrapping up businesses, etc. The durable power of attorney can be either a immediate power or a springing power. Generally, for clients, we set it up so that it is immediate with respect to the spouses, but springing with respect to any other fiduciary. The next document that we always include is the Advanced Healthcare Directive, the document that outlines the client's specific wishes with regards to their medical care in the event that they are unable to articulate their wishes themselves. This includes decisions such as whether they would like blood transfusions, whether they would like organ donations, whether they would like to receive medication even if it hastens their passing, whether they would like to pull the plug or stay on machines until the absolute end. All of these decisions are personal, and each client gets to make that decision for themselves, and it is our job as attorneys to make sure that those are properly recorded in their Advanced Healthcare Directive. It is important to note that there is the Advanced Healthcare Directive recognized by the state of California, which we provide as part of our estate plan for each of our clients. There is also the VA-specific healthcare directive, which many clients have completed at the VA itself. We need to make sure that clients know that the VA-specific form is only valid at the VA, whereas the Advanced Healthcare Directive that we complete as part of their estate plan is valid at any medical facility nationwide. And it's not always possible that they're going to be rushed via ambulance to the VA clinic. It's quite possible they might be rushed via ambulance to the nearest clinic. So it's very important to have the Advanced Healthcare Directive the California version. The next document that we include in our estate planning portfolio are the final disposition instructions. The final disposition instructions is the document that says exactly what you or your client wants with the remains when you are gone. Do you want to be buried in a national cemetery? Do you want to be cremated? Do you want to be scattered at sea? Do you want to be put in the family plot with your spouse and loved ones? Whatever the decision is up to you. But it's important that we make sure to note in the final disposition instructions exactly what your wishes are and who you want to be in charge of carrying out those wishes. Another document that is included in the estate planning portfolio, if applicable, is the standalone nomination of guardian for minor children. We generally do this as a package that includes not only the standalone nomination, which nominates a guardian both temporarily and permanently, but also we include a power of attorney and a power of attorney for healthcare for the children, which allows a designated person to take care of the children when the parents are unavailable. Maybe it's because they're taking a well-deserved vacation overseas and the children are staying with grandma and grandpa for a week, or maybe it's because of an emergency health situation and the designated persons will be caring for the children longer. Either way, we want to make sure that those guardians have the ability to enroll the children into school, take the children to doctors when needed, and so on and so forth. Another very important document to include in the estate planning portfolio is the deed. If the client has real property, especially in California, it is very, very important to prepare the appropriate deed, transferring the property from the current ownership, whether it's owned as an individual, joint tenants, community property with right of survivorship, tenants in common, whichever way it is owned, it needs to be transferred to being held in the trust. Finally, we also prepare ancillary documents as needed. These include things such as assignments, summary of all of the documents included, any pre-need forms, and this will vary significantly based on each client. For example, in the estate clinic, we once had a client who owned several trademarks, and so we wanted to be sure to specifically put those trademarks assigned into the trust. So, as I mentioned, your entire estate planning portfolio will be very unique, and it will be made up of several documents, usually about 6 to 12 documents in each complete plan.
A trust only protects assets properly titled in the trust. We're going to provide trust funding instructions when we provide the hard copy of the trust, how to use the certification of the trust, how to update beneficiaries on life insurance, retirement accounts, etc. We also will record the deed Sheila-Marie mentioned, transferring the property into the trust. Sheila-Marie's firm, Ahava Law PC, has generously volunteered to record these deeds for Veterans Legal Institute estate plans.
Next, we're going to talk about veterans benefits as they apply to estate planning. It's important to note that veterans benefits is a very broad topic, and there is a separate video that summarizes those specifically. The primary thing that you need to know is to encourage your clients and any other current service members or veterans that you know to apply for the veterans benefits as soon as possible. The longer they wait to apply, the less benefits they will be entitled to and able to receive. For example, if you immediately upon discharge walk across the hall and apply for your benefits, often you will receive full dental as well as medical and all of the other benefits you're entitled to. However, if you wait a year, you will no longer be eligible to receive those dental benefits. So it's very, very, very important to apply as soon as possible. The best day to apply for benefits is yesterday, just like the best day to create your estate plan is yesterday. Because if you wait to create it when you need it, often you will no longer be able to create it, either due to death and incapacity. With regards to veterans benefits for estate planning, there are a couple of forms that you and your client need to know. First is the VA pre-need eligibility form, number 40-10007. This form is important because it used to be that your client had to die before your family could find out if they were eligible to be buried in a military cemetery. Now, your client can apply online and find out in advance their eligibility, and then you can include that document with their estate planning portfolio. Please note that you need a separate application for the veteran and their spouse, and both will need a copy of the veteran's DD-214 discharge papers. Also, please note that this is the process for burial or interment in the veterans' national cemeteries. State cemeteries have separate forms for their veterans, so you'll need to look specifically at each state. For example, in California, the veterans will be interred or buried as part of their veteran benefits. However, to inter or bury their spouse, the spouse would need to pay the separate fee for them, which is currently $893. Finally, there is a VA burial allowance form, which is form number 21P-530. This form can be used to apply for burial allowances when the veteran is not going to be interred in a national cemetery, or if you want to apply for things such as the medallions on their headstones.
Veterans Legal Institute is always looking for pro bono attorney volunteers to help us not only with estate planning, but in other areas of the law. If you are interested in providing pro bono services for Veterans Legal Institute, please email info@vetslegal.com or visit vetslegal.org. This video was made possible by a generous grant from the California state. This video provides general information relevant to the state of California and is not to be construed as legal advice.